SOAS to hosting this event, which is really timely because next week on the 18th of May, we commemorate the 10th anniversary of the end of the war in Sri Lanka. Mulivaikal Remembrance Day really marks a low point for the world in terms of whether the international community did enough to ensure that the hundreds of thousands of civilians who were killed in that war in fact were protected in the way that they should have been. We also know that more than 500 people, including women and 23 children, were the victims of the crime of enforced disappearance, the highest number of people who were disappeared in a single event over a 3-day period. The Sri Lankan government, of course, argued that they were fighting an asymmetrical war in which the laws of war were suspended, an argument which I think I and my colleagues debunked in the UN panel of experts quite soundly. The panel, which I was part of also found that both the government of Sri Lanka and, of course, the LTTE had in fact committed war crimes and crimes against humanity. But it also found that, in fact, most of the violations and that the government of Sri Lanka had been quite a major perpetrator. The panel, of course, was also able to debunk the theory that the government of Sri Lanka had mounted a humanitarian rescue mission, and the notion that there had been a policy of zero civilian casualties. And at that point, we estimated that around 40,000 civilians had been killed during the final stage of the war. And the panel's report, which the government of Sri Lanka refused to accept, certainly made it possible for the United Nations Human Rights Council to establish an independent commission of inquiry into the conflict in 2014, which was known as the OISR inquiry. They published their report in September 2015 and found that the government of Sri Lanka had committed gross violations of international human rights law and serious violations of international humanitarian law amounting to war crimes and crimes against humanity. They also found that the LTTE had also been responsible for war crimes and serious violations of international human rights law and international humanitarian law. But the important thing about the OISR inquiry was that it provided an important advocacy point for civil society groups in Sri Lanka and the international community, which led to Resolution 30/1 in the UN Human Rights Council, and which committed the government of Sri Lanka to establishing a comprehensive transitional justice strategy, which included establishing a Truth and Reconciliation Commission, an Office of Missing Persons, a special hybrid court, a comprehensive reparations process, and of course the vetting and screening of public officials. These commitments, of course, were reiterated in Resolution 34/1, which was passed by the Human Rights Council in March this year. And of course, to date, there have been some institutional coordinating mechanisms which were established, including the Secretariat for Coordinating Reconciliation Mechanisms and the Office for National Unity and Reconciliation. But critics of both of these entities have suggested that they lack the strength and resources to effectively perform their tasks. The Office on Missing Persons was established, but has also had a limited impact in Sri Lanka. The OMP has no teeth and is unable really to deal with criminal accountability. Moreover, in 2018, the Office of the High Commission for Human Rights found that the relevant reforms in law relating to inquest, the relevant protocols to operationalize the law must be undertaken in order for the Office on Missing Persons to better perform excavations, exhumations, the investigation and identification of human remains. In 2018, an Office for Reparations was set up. And at the beginning of 2019, some commissioners were appointed, but that office is yet to become operational. But colleagues and friends, if we are all frank with each other, it's been more than 10 years since the war ended. And in that 10 years, there's been an absolute failure to ensure that the government of Sri Lanka does what is necessary to hold those responsible for war crimes and crimes against humanity accountable. The bombings in Sri Lanka, which led to the tragic death of more than 200 innocent civilians, has certainly ensured that the transitional justice process in Sri Lanka is dead. And in fact, the interests of security, and once again, I think will trump the notion of human rights and the rule of law. And really, this is a failure of the international community, and of course, a failure of the international system, really, to ensure that Sri Lanka pursues a justice agenda. And once again, we are all compelled to go back to the drawing board. In the absence of any accountability measures in Sri Lanka and the necessary pressure from the international community, organizations like many of ours sitting in the room here, many people sitting in the room here today, means that we have to be creative and we have to recalibrate our approach to this question of accountability. While we used our documentation initially as the ITJP to support the OISL inquiry between the period that the OISL was busy with its work, in reality, following the end of the OISL report and the institution of a new regime in Sri Lanka in 2015, there have been very few organizations who have continued to document ongoing torture and ongoing sexual violence in Sri Lanka, which is not surprising, really, given the lack of commitment by the Sri Lankan government to dismantle a corrupt security establishment, including holding those accountable and alleged to be responsible for those crimes. That is certainly one of the reasons why these violations have continued. In addition, the government has continued to deny the ongoing violations and is supported to some extent by some civil society organizations in Sri Lanka who supported the Sirisena regime uncritically and refused to countenance that the security structures responsible for the violations largely remained intact and have not been dismantled at all. This year, the High Commissioner's report to the Human Rights Council set out in paragraph 56 unequivocally their concern that the ongoing torture, including sexual violence, continues. We are, of course, living in a global world where human rights is under siege and the appetite for criminal accountability for grave crimes is diminishing, and where most countries, even the United Nations, increasingly prefer to deal with development and technical capacity, as this is less likely to cause controversy. In fact, 2 weeks ago, the director of Human Rights Watch, Ken Roth, wrote a devastating critique of the Office of the Secretary General and his failure really to raise his voice in response to the human rights situations which are developing across the world. And so, given the lack of legal options available and the absence of political will in Sri Lanka to deal with alleged war criminals, we have had to decide, how do we use the rich archive that we have gathered, in fact, to promote some form of accountability? And so we decided at the ITJP that we would promote truth recovery by publishing dossiers on perpetrators. We would use the UN special procedures, including making submissions to the UN Committee on Torture, the CEDAW Committee, support the work of the special rapporteurs, and promote accountability by bringing cases outside of Sri Lanka under universal jurisdiction, and of course also under torture protection laws in the United States to at least build some accountability for the victims. The issue of enforced disappearances is extremely troubling, and so in 2014, the ITJP published the names of those victims who were subjected to enforced disappearances on and around the 18th of May, based on witness accounts of surrender to the Sri Lankan forces. Our current list exceeds 350 names of people who surrendered to the security forces, and of course included in there are 29 children. We produced a website this year with names and photos to share this information with the wider public in the hope of gathering leads as to what had happened to people, and as part of the wider truth recovery process also relating to the work of the Office of Missing Persons. The ITJP, together with the Human Rights Data Analysis Group, led by Patrick Paul, launched a project which is in fact dealing with this, and what we would like to encourage all of you who have relatives or who know of people who were disappeared in that period to in fact take part in the project. But of course we also reached out to the Office of Missing Persons and offered to assist them in dealing with their work. But we also said to them that in fact the truth lies within their hands, and that they have in fact the power to in fact subpoena the Sri Lankan commanders who were in the area that particular day, and in fact to demand answers from them about the people who were handed over into their custody. And of course, to date, that has not really happened. In 2017, we also made a submission to CEDAW around sexual slavery, and we drew attention to the existence of rape camps which were run by the military after the war, based on the testimonies of our survivors. We also drew attention to the issue of male sexual violence in Sri Lanka, and actually we put this on the map by publishing a report analyzing 121 cases, really puncturing the myth that exists out there that victims do not disclose because of stigma or because no documentation exists. The report actually speaks to horrendous crimes and inventive forms of sexual violence and torture perpetrated mainly against Tamils in detention by the Sri Lankan security apparatus. The report also challenges the traditional perceptions of conflict-related sexual violence, and this, of course, is an issue that we continue to document. Our work, of course, has been extremely useful in terms of peacekeeping and vetting, and in fact, our intervention in February 2018 led to the suspension by the UN of the deployment of Sri Lankan peacekeepers until this year. We've also continued to push the UN on its past failures in vetting peacekeepers, dating back a decade to Mali, Lebanon, Darfur, South Sudan, East Timor, and Haiti, producing numerous dossiers and sharing them with the UN and briefing the UN apparatus on a number of occasions. In October 2018, the Sri Lankan contingent commander in Mali was repatriated as a result of our efforts. And of course, over the years, I think we have developed quite a unique expertise in researching these individuals and assisting the enhanced vetting by the UN in 2016. We've also drawn attention to problematic international appointments. Don't you find it shocking that people who have a war criminal record are actually posted abroad? They're rewarded for the fact that they participated in really grave crimes, and instead of holding them accountable, they are sent abroad to hold particular office. Currently, one would think that in the United Kingdom, given the problems they have had around the defense attaches appointed here to the UK, the Sri Lankan High Commission, you have another one who's been appointed, who should have been vetted out and not given a visa to come to the United Kingdom. And I think this is where civil society needs to do its work, and to ask the United Kingdom questions around why you have such questionable people allowed to come to the United Kingdom. After all, don't they also have a responsibility to the population over here. We've also shared evidence spanning decades, a decade of the violations of the last decade, and we have provided information on multiple occasions to the Office of the High Commissioner, to multiple UN mechanisms, prosecutors, and of course war crimes units in many places. We also, when Sri Lanka appeared before the UNCAT committee in Geneva, established that a man who was the Deputy Inspector General in charge of the CID in Sri Lanka, with oversight over the TID, was in fact part of the delegation that the Sri Lankan government sent to Geneva. And of course, if one looks at both the CID and the TID, these were police units run as responsible for torture and sexual violence during the period when Mr. Mendes was in charge. And in fact, the UNCAT committee described that the torture was routine and systematic and was part of a deliberate policy rather than an isolated act. And so, of course, we raised the fact in a dossier about him, and in fact, he was asked many, many questions about his participation in the Sri Lankan delegation in Geneva. He enjoyed immunity, so we could not actually do anything about making sure that he would be held accountable there and actually arrested for his role in the torture in Sri Lanka. We've continued, of course, to prepare perpetrator dossiers, and on the 28th of August in 2017, we filed a war crimes case in Brazil and Colombia against Sri Lanka's ambassador, General Jagat Jayasuriya, for his role in the final phase of the civil war in 2009. He was the former commander of the Sri Lankan army during the final phase of the war, and in that context, we were pursuing him on the basis of his command responsibility. Of course, on the night before we were going to serve papers on him, he fled Brazil in the night like a common criminal. And of course, while we tracked him to Dubai, we were unable to do anything about that. And on his arrival in Sri Lanka, he complained that he would be unable to travel in the future given the possibility of arrest warrants issued against him. The government of Sri Lanka, of course, lamented that he had fled Brazil and instead claimed that he had come back to Sri Lanka as planned after ending his term in Latin America. And President Sirisena at the time was quite adamant that he would not allow any pursuit of accountability and have the image of war heroes tarnished. He was quoted as saying, "I state very clearly that I will not allow anyone in the world to touch Jagat or any other military chief or any war hero in this country. His war heroes are in fact alleged to be major perpetrators of serious international crimes." In March this year, of course, the Human Rights Council essentially rolled over the resolution on Sri Lanka, co-sponsored by the government. But as I have said, I think we should largely acknowledge that any opportunities on that score are largely dead. Of course, the government of Sri Lanka at the highest political level has said both publicly and in discussions with the present and former High Commissioners for Human Rights that constitutional and legal challenges preclude it from including any non-citizens in its judicial processes. And if one thinks about the hybrid court that was supposed to be set up by Sri Lanka, it is unlikely that it will ever be set up and that you will ever have any judges or prosecutors from any other jurisdictions. And for many victims, this represents a failure as the prospect of criminal accountability for serious international crimes becomes even more remote. And so as we commemorate this 10th year since the end of the conflict, many victims in fact express intense despair with the inability of the international community and the government of Sri Lanka to hold those responsible for war crimes and crimes against humanity accountable. In March this year, of course, the ITJP and a US law firm, Hausfeld, filed a civil damages case in the Central District of California against the former Sri Lankan Defense Secretary Gotabaya Rajapaksa on behalf of a Tamil torture survivor, Roy Samadanam. Gotabaya Rajapaksa, a dual US Sri Lankan citizen, had travelled to the US, in fact, to begin the process of renouncing his US citizenship. We had secured the services of a private investigator to track him down, and he was formally served with papers on a Sunday night at Trader Joe's parking lot in Pasadena. Of course, it's important to remember that Roy Samadanam is a Tamil civilian with Canadian citizenship who was arrested in Sri Lanka in 2007 on what his lawyers say were false charges of illegally importing a GPS device, and he was then tortured by the TID, which are notorious for their torture methods, which was under the command and control of Gotabaya Rajapaksa at the time. And following physical and psychological torture, our client had been forced to sign a false confession. He was released in August 2010 on a plea deal and the payment of a fine. But in December 2016, in response to communications made formally by our client, the UN Human Rights Committee found Sri Lanka to have violated a number of the provisions of the International Covenant on Civil and Political Rights and requested that Sri Lanka conduct a thorough and effective investigation into the facts of the case to prosecute, try and punish those responsible for violations, and to provide adequate compensation and appropriate measures of satisfaction to Roy for the violations suffered. And of course, to date, Sri Lanka has failed to abide by this decision. While the case has a long way to go, and of course there has been a separate case filed by the Centre for Justice and Accountability on behalf of a prominent Sri Lankan investigative journalist, Lasantha Vikramatunga, who was bludgeoned to death by men on motorcycles who surrounded his car. Both cases have a long way to go. And this, of course, is probably the only opportunity to begin to hold anyone accountable, because we are not sure about whether Mr. Rajapaksa intends to stand in the presidential elections. Last Monday, our lawyers in the US also filed a cease and desist application against Mr. Rajapaksa, setting out that there had been a number of attempts to intimidate our client and even to bribe him to drop the case. Annexures that are attached to the court record show that our client was actually asked how much money he wanted to drop the case. So you should keep a watching brief, and we will see how this actually goes. So I think the big question we have is, what are the prospects for accountability in Sri Lanka? You're going to tell me if I'm running out of time. We know that the government has demonstrated a lack of willingness to prosecute anybody for serious crimes. And of course, many of them continue to occupy important functions within the security sector. In January 2019, Major General Shivendra Silva was promoted and of course is arguably the most important frontline ground commander in the 2008-2009 war in Sri Lanka, and in my view should stand trial for war crimes. We have prepared an extensive dossier on him, and it probably constitutes the most detailed body of evidence against any Sri Lankan military figure to date. But of course, the Office of the High Commissioner itself has indicated that the regular criminal justice system in Sri Lanka continues to suffer from serious structural weaknesses in terms of investigating and prosecuting international crimes. A 2017 report by the UN Special Rapporteur on the promotion and protection of human rights while countering terrorism also found that there is no formal procedure available to detainees in the prison system, and there is no single clear challenge for dealing with allegations of ill treatment committed by the police. In addition, the politicization of the Office of Attorney General, as evidenced by a number of reports, also worsens the situation. In particular, in the situation where fundamental rights applications are filed in the Supreme Court. And by way of example, in torture cases involving PTA detainees, the Attorney General not only represents public officials named as respondents in those cases, which goes against the common practice and the rule of law, but also adopts delaying tactics by requesting further time to complete investigations or to file an indictment. And so, of course, none of these cases actually come to any kind of fruition. And while Sri Lanka has enacted the Torture Act and, of course, the Enforced Disappearance Act, it's not a state party to the International Criminal Court and has not included serious international crimes in its penal code, including relevant modes of liability, which would allow the prosecution of superior officers and commanders. Sri Lanka has also failed to establish the hybrid court that would be responsible for trying international crimes committed during the Civil War. And of course, both the President and the Prime Minister have made statements denying the need for foreign assistance. And in fact, in 2016, President Sirisena was quoted as saying, "As long as I am president of this country, I will not allow for any international court, international judges, and international organizations to interfere with the internal affairs of Sri Lanka and the judiciary." During the last session of the Human Rights Council this year, the Minister of Foreign Affairs also stated that any internationalized mechanism would require constitutional amendments, which are unlikely to happen, really suggesting that it is highly unlikely that any hybrid court will be established in the future. So I guess the question is, given the fact that you cannot pursue justice at a domestic level, and of course that it's increasingly difficult at an international level, all of us have to consider, what do we actually do? So let me say that I think a very useful form of promoting truth recovery is filing individual communications before treaty bodies, CEDAW, the UN Human Rights Committee, the UN Committee Against Torture. And while this approach is, of course, likely to bring the relevant cases into the spotlight, and what it does do is create international pressure, and it serves as an excellent advocacy tool for civil society. Of course, many countries say that the findings of these bodies are merely advisory, they represent guidance, and they're not really obliged to implement the rulings. And so from the perspective of enforcement mechanisms, this remains, of course, a grey area. Sri Lanka is not a state party to the Rome Statute, but of course, if one considers the kind of creative footwork that we have seen around the Rohingya question and Bangladesh, one could always begin to ask the question whether this is something that we could begin to pursue. Another suggestion that we made to the government of Sri Lanka was that it could also establish a commission similar to the International Commission Against Impunity in Guatemala, which was mandated to investigate and co-prosecute with the Public Prosecutor's Office, the police and other state institutions, and in fact cases involving criminal networks that had emerged as a grave threat to the rule of law since the end of the conflict in Guatemala in the 1990s. And if many of you followed the work of CCRJ, and you looked at the kind of arrests that they made, this is certainly an option. It would also bring foreign experts to the table, and they could certainly play a more advisory role, with Sri Lankan investigators and prosecutors playing a leading one. Moreover, there would be no international judges, as these cases could be adjudicated before the Sri Lankan courts. The question, of course, is whether the courts have the capacity to pursue such cases. Another model, which was followed by the Argentinians, were in fact the truth trials, as they became known in Argentina, and were really an innovation in the country's justice system, and possibly in the whole of Latin America. They were unlike ordinary criminal trials in that judicial action was expressly limited to investigation and documentation without there being a possibility of prosecution or punishment. And they were really based on the notion of the right to the truth, both for the individual relatives and, of course, society as a whole to pursue the truth. So this is certainly something that one could consider. Another, of course, is involving international independent experts from non-governmental organizations and investigating and prosecuting international crimes at a national level in the form of some kind of assistance. And if you look at what Trial and Physicians for Human Rights have been doing in assisting with sexual violence cases before the military courts in the Eastern DRC, these could be some options if, of course, there was political will. Of course, the big question is universal jurisdiction, which is based on the premise that certain crimes are so heinous to the international community and that they must be prosecuted regardless of the location of the crime or the nationality of the perpetrator or the victim. In 2012, Amnesty International found that at least 95 UN member states had included torture as a separate crime under national law, not as a war crime or a crime against humanity, and that at least 85 UN member states had provided for universal jurisdiction over this crime. But in reality, if you actually begin to investigate national jurisdictions, you find that it's much more trickier than it's actually out there, and I'm sure Rupert will also speak to that. And so I think at the end of the day, what is really very, very clear is that we have to recalibrate what is happening around this question of accountability. And we have to find creative ways in beginning to promote the truth, in ensuring that people actually don't travel around the world, that they're afraid to because of the possibility that they may be indicted and arrested, and that we also need to find other forums for doing this kind of work. So really investigating which countries which have domesticated the torture convention in their national law. This is something that we need to look at. And of course, the other way is, of course, bringing civil claims like we have under the Protection of Victims Act for torture in the United States. And these may certainly be options. But at the end of the day, we need to ensure that there's a lot more advocacy. And so in the coming weeks, I mean, what we have seen are the deployment of the security forces in Sri Lanka. And of course, shockingly, a number of the middle-level commanders who have been deployed are also people who have records of having violated other people's rights during the final phase of the war. And so you will have new targets of persecution. And what we need to do is also ask the question, what are our solidarity efforts going to be, even though in this time they are not Tamils, but actually Muslims? What are we going to do to speak up about rights violations, and how are we going to ensure that human rights and the rule of law do not become impaired in dealing with this new fight against terrorism and extremism? Because in the end, what often happens is that human rights and the rule of law become sacrificed. So we need to explore what we can do to support the larger question of the human rights of all communities in Sri Lanka. And that means we have to go beyond our own particular struggle. Thank you.